Deciding, many regard the decision as to whom to make one's heirs as the biggest legacy question. In some families, particularly those having insubstantial property to transfer from one generation to another, heirs are not a big issue. The legacy is instead in the love, society, companionship, memories, values, and commitments the decedent reflected, not in the property the decedent left behind. Yet in other families and situations, particularly those involving transfers and dispositions of substantial generational wealth, the decision as to whom to include and whom to exclude as an heir, and what divisions of what property and interest to make in a will and broader estate plan are indeed huge legacy questions. And that's true not only because the property may be so substantial as to be life-changing for its recipients, but also because of the relationship and values the inclusion or exclusion of heirs reflects. Excluding an obvious and natural heir is surely a judgment of some sort, one that may, for better or worse, change a legacy. Goals. When deciding on heirs, one does well to think first about legacy goals. Testators can have several legacy goals they hope to achieve through choosing heirs. At the deepest level, testators generally want their decisions on heirs to reflect certain values and commitments. Otherwise, they may as well just roll the dice, making bequests into a game of chance. Equality can be a major goal. Some testators, for instance, will treat their children equally no matter how good or bad, and close or distant their relationships are with their children. Other testators may have equity rather than equality as their goal. If one child cared for, served, and honored the testator far more than another child, throughout a lifetime and especially in later years, and that child would benefit far more from an inheritance and even needs an inheritance because of the child's sacrifices for the testator, then equity would demand substantially different bequests. Provision and care can be other goals, measuring bequests by the degree to which children may need or benefit from them. Whoever your natural heirs are, and whatever your circumstance is, first consider the goals you want your bequests to achieve, and the values you want your bequests to honor. Spouse. Your spouse is an obvious heir, indeed perhaps the most obvious and natural heir. Although many parents would first think of their children, if your spouse survives you, then your spouse may need to retain everything that the two of you own, for your spouse's support after your demise. A common arrangement is for each spouse to bequeath everything to the other spouse, and only then, if the other spouse does not survive the testator, make bequests to children or other heirs. But you and your spouse are the judges. If the two of you agree that your estate is substantial enough to provide for your spouse and to bless your children or other desired heirs with their own bequests, then do so. You and your spouse each get to decide. You do not make a joint will. You instead each make your own wills, and you may each do so based on your own choices. Yet you and your spouse should share your wills with one another when executed. The survivor of the two of you will find out eventually, and your bequests, with which your spouse disagrees, can affect your spousal relationship. Most states also permit a spouse to elect a share of your estate against whatever your will says, for the purpose of ensuring your spouse's support. Work closely with your spouse to make the best decision together. Honoring your spouse honors your marriage and blesses your children with that honor. Your children should understand if your surviving spouse gets to enjoy your full estate until your spouse passes away, and, in doing so, determines their inheritance. Divorce. If you have divorced, then you should revisit any will you made while married and any related joint deeds, titles, or other aspects of your estate plan. Neglecting to update your bequests after divorce can seriously adversely affect your legacy. In many states, divorce automatically revokes bequests to the divorced spouse and any related rights such as the ex-spouse's appointment as personal representative. But that's not true for all states, and you may not want your estate going to and controlled by your ex-spouse rather than your children or other natural heirs. Revisit your will to amend it or revoke it in favor of a new will, accounting for your divorce. Don't ruin your legacy by neglecting the implications of your divorce on your will and estate plan. Remarriage. The same is true with remarriage, that you should promptly revisit any will and estate plan you made before remarrying, unless your will and estate plan fruitfully anticipated your remarriage. You may want to bless your new spouse with a bequest. You may also want to recognize in your will any children you and your new spouse have together. You may also want to account in your will, one way or another, for your spouse's own children by a prior marriage, those who would now be your stepchildren. You may also want to ensure, though, that your remarriage does not unduly adversely affect your estate plans for your own children from your prior marriage. Your children's concern for protecting their inheritance against the ways and wiles of your new spouse may deeply affect your family's relationships, unless you deal effectively with their concerns. Work it out the best you can, protecting and honoring your children while also honoring your new spouse, to preserve and enhance your legacy. Remarriages can scramble the legacy egg. Be sure you find the right legacy recipe. Parents. If your parents are living when you execute your will, you may wish to provide them with a bequest in your will, contingent on their surviving you, if doing so would aid their support after your passing. You may, though, have better ways to provide for their necessary support in your absence, such as through a life insurance policy, family trust, or commitment you gain from your spouse or a sibling to continue to care for them after your passing. The inheritance rights and interests of a parent are not generally a substantial concern when executing a will, given the unnatural order of any such passing of a child before a parent. Just be thoughtful about any potential legacy issues or concerns when executing a will while your parents are still living. Children. After your spouse, your children are your most obvious natural heirs. How your will and estate plan treats your children may be your biggest legacy question. If you have one child, leaving your main bequest to that child could be an easy call. If you have multiple children, dividing your bequests equally among them may likewise be an easy call. While you may make equal proportional bequests to your children, don't miss the opportunity to increase sentimental value with specific bequests of items that mean more to one child than to another child, provided that you otherwise equalize market values. If one child values your rocking chair, while another child values your desk, then make specific bequests of those items to those children, or give them the items before you pass. The bigger question can be whether to make unequal proportional bequests among children. One sound rationale for unequal bequests can be the greater need of one child than another, especially if you have a disabled child incapable of providing for the child's own needs. Your other children would likely understand if you favored the disabled child with your bequests, on support grounds. To enhance your legacy, be thoughtful about your children's critical needs. Disfavor. Another rationale for unequal bequests among children can be the relative quality of the relationships you have with your children. Some children break off all relationships with their parents. Other children neglect their parental relationships. Other children act disrespectfully toward their parents, even undermining their parents' interests, reputation, and relationships with slander and by other means. Some children are even violent and abusive toward their parents, or commit theft, conversion, and embezzlement of their parents' property. Children can unfortunately supply good reasons for their parents to disinherit them. Treating children with equal bequests when all children are aware that one child has dishonored the parents, or even abused or exploited them, can detract from your legacy. To preserve and enhance your legacy, have your bequests represent your commitments and values, especially those that your natural heirs would recognize, respect, and honor. Unequal bequests among children may in special circumstances be the sound and proper course for preserving and promoting a legacy. Disclosure. You may wonder whether to disclose your estate plan to your children or other heirs, especially in situations like the ones just discussed, where you have planned unequal bequests based on sound rationales you'd expect your children or other heirs to appreciate. You may want to explain those rationales to your heirs to help them understand your intent, prepare for the outcome, and avoid surprise and confusion. Yet your disclosure may sow resentments, disrupt existing relationships, and discourage reform and renewal of those relationships that might otherwise have naturally occurred. Your disclosure may also cause complaints in campaigning that you'd rather avoid. You may also later decide to change your estate plan, which you might then have to once again justify. Generally, keeping your estate plan confidential, except for your spouse and perhaps your adult child personal representative, is the better practice. But you be the judge. You know your family. Just keep in mind their personalities and likely reactions, and take the best course to preserve and enhance your legacy among them. Adoption. When planning bequests to children, your biological children may have expectations of a greater inheritance than adopted children. Conversely, your biological children may expect or prefer that your adopted children receive the same shares as they receive. The relative needs of biological and adopted children, and the relative quality of their relationships with you and with one another, may also be factors in any distinctions, just as discussed above with all biological children. You be the judge, but be a wise judge, one who enhances rather than detracts from your legacy. The print and digital guides include abundant additional information. Thanks for watching. Get more tips plus illustrations, summaries, forms, and reflections in the guide at the link in the description.